All right, it is full disclosure Thursday. Yes, another Thursday. Another Haley. It's great to see you here again, and we have the pleasure of having Jennifer Jaynes on the phone today, trust attorney or estate planning attorney extraordinaire. And thank you, Jennifer. I know you're at an emergency signing and dialing in to be with us today. So thank you, thank you.
Of course, thank you for having me. It's always a pleasure to speak to you guys. Happy to answer any questions that you have.
Awesome. Thanks, Jennifer.
So great. So ultimately, we advise people all the time to, get your affairs in order, put together an estate plan. In a nutshell, can you tell us, Jennifer, really what you're achieving when you put together an estate plan and put together a trust for a property that you own?
Yeah, certainly. So again, I apologize for not being on video right now. I am in just kind of the Oakland Hills where the service is not so great doing an emergency signing, or sometimes we call them deathbed signings. So don't wait till the last minute because you have to turn these around relatively quickly and then everything's an emergency. But in any event, what we're
Mm-hmm.
trying to do when I'm doing an estate plan is protect the individual from incapacity, and also in the event of death ensure that their wishes are followed. So a lot of times people think, well, I'm going to be dead, who cares, you know, and they'll
I
just
know.
leave it up to the family members. But the truth is that you're also protecting your assets while you're alive in the event that you're unable to manage them. So we always say that whenever we're preparing a trust or an estate plan for somebody, we're preparing all the documents that are necessary to, in the event of incapacity, ensure the person that you want to manage your finances is stepping into your shoes and acting for you during that period of incapacity. And then also appointing somebody to step into your shoes in the event of death, clean up all of your affairs and make sure your wishes are followed. So it's not just to avoid probate, although that is one of the most important reasons to do a trust, but it is to protect in the event of incapacity as well.
Excellent. So am I now? This is a rudimentary explanation, but would it be okay to say that, if you were not to do something like this and a horrible event were to happen, like your passing in a accident, or a plane crash, or God forbid what it might be, if you did not have a trust and probate got involved, probate gets really expensive, right, when you're dealing with the courts. And
Yeah.
the like when you have the likes of Tony Shea, the owner of Zappos, who's worth almost $1 billion, who passes away uh, intestate, without a trust, without a will. The the state, or the government, are probably going to walk away with half of his estate, or a very sizable chunk, right?
Well, so that's actually a common misconception about probate. You know who really benefits out of probate is the executor of the estate, which is oftentimes a family member, so they don't really care.
Mm-hmm.
Although they do have to pay income taxes on it. But the other person that benefits from the estate is the attorney that represents the executor. So whoever's representing the executor in that estate is going to get a pretty payday at the very end of that probate. Because what happens with probate is that it's not the state that takes the funds, and it's not even the court, although there's a couple, filing fees that you have to pay. But what happens is that the executor fees and the attorney for the executor fees are based on the gross percentage of assets that go through probate. So I'm just going to give you a real quick example because it's easy to do with a home that's worth $1 million, and it
Mm-hmm.
may have a $700,000 mortgage on it. Even
Mm-hmm.
though there's only 300,000 in equity, the attorney and the executor get paid on the $1 million property. And
Oh,
so it's
wow.
a percentage of the assets that go through probate, and it's 4% of the first 100,000, 3% of the next 100,000, 2% on the next $800,000 and 1% on anything over $1 million. So on $1 million gross estate, you're talking about $25,000 in attorney's fees for the executor, and then $25,000 in attorney's fees for the attorney. So $50,000 off the top, and that's just on a $300,000 estate, really, in net equity. I mean, that's not so. It before
and the
anything
property's not
goes-
even sold yet, so that money has to come from, if that's transferring or yeah, that's so can I be the attorney on the Tony Shea estate?
I mean, it probably will take over 3 years to close. So sure, go to law school, pass the bar, and then you can be the attorney.
Excellent. So really, the ease of these process. I having gone through the process, I know that really that the hardest part of it is sitting down to actually make the decisions of who is going to be the person who does this and who is going to be the person that does, because you have to have these conversations with people and that kind of stuff. And really, the setting up the trust and the cost of the trust are not really big barriers to it. It's really just making decisions.
Yeah, and some people find it more difficult than others, but I oftentimes have clients say to me at the end of the process, "Wow, that was relatively painless," because a lot of the information where clients, I can assist through that process, right? That's why you hire an attorney. You hire an attorney to provide you the advice and counsel, so you're not just going through and filling out blanks, in a form doc that's not going to cover all of the what ifs. And so the attorney is really there to help you make good decisions, and then also cross the T's and dot the I's for all the contingencies. Well, what if this, then that? What if
Yeah.
this, then that? None of that happens with those fill in the blank forms. And oftentimes they're done just so inappropriately that they might as well have not been done at all.
Yeah.
And so the cost of doing a comprehensive estate plan ranges between, $2,500 for the most simple estate plans for a single individual to, $4,000 for more complex married couple estate plans. And that, if you're just talking about the probate fees that we just talked about on a, $1 million estate that had only 300,000 in equity, that's going to cost you 50,000. You might as well have just paid the flat fee to do a comprehensive estate plan. Get it taken care of. You're protected in the event of incapacity and also in the event of death, completely avoiding the court process when there's administration of your estate. And furthermore, what people oftentimes will say is, well, do I have to update this all the time? Is it going to cost more money on a continual basis? And that's often a misconception. People in general, if you work with an attorney and do it right the first time and the contingencies are accounted for in the plan, they don't change their estate plan more than 2 to 3 times over the course of their life. And that's on average, so it may be that you only change it once or not at all, depending on when you start. And so there's not a lot of continual cost to setting it up.
And then what about the process of putting assets into the trust? That's really with financial institutions and stuff like that. That's all very straightforward and simple. Just a matter of kind of filling out some paperwork and kind of getting it added to the trust. But they're in California. I'm not sure if this is just California or if this is a nationwide scenario. There is some sort of ability that if something was forgotten about, like sometimes people, buy a property and don't put it in the trust, or refinance a property and don't put it in the trust when it gets refinanced or something like that. There is a process where that can get added in after a incapacity event or after a tragedy and stuff like that. Is that correct?
Yeah. So the trust is just one piece in the estate plan. There's also something called a pour over will. The pour over will is meant to be a catch-all to get anything that might have been missed into the trust post-death. The problem with the pour over will, though, is it doesn't avoid probate for that one asset or two assets, but it eventually will get the asset into the trust. You just have to probate it first. There's also a case and a type of petition that we use called a Heggstead petition that says that, if the settlers intended to transfer it into the trust. And we can prove that with a copy of the pour over will, as well as, you know, the asset was listed on the schedule of trust assets. We can just prove the intent of the settler was to put this in the trust. We just file a simple petition and we get it into the trust without actually having to probate it. So it just depends on the circumstances. But the goal is that when somebody signs an estate plan or a trust for that matter, the attorney should be giving you the right advice and counsel in terms of trust and funding. And I can transfer from my clients' business interests, California real estate, and all their tangible personal property. So vehicles don't need to be titled in the name of the trust, all their stuff, furniture and furnishings, contents of their home. The only thing the clients need to do is transfer bank and brokerage accounts and update beneficiary designations on retirement and life insurance policies. But their attorney should be helping them do that. It's just that the attorney can't do it for them, unless you want to pay the attorney's hourly rate to do it. But your signature is required on the bank forms. So ultimately, you're going to have to sign the forms at the bank anyways.
Okay. And so how does one show, just that's a curious question, how does one show that their intention was to transfer something into the trust if, you know, they've passed away and this is something that's maybe been forgotten about? Should people on an annual basis write down things that should be in the trust, or what, how would somebody, you know, who transacts, especially in, say, real estate, on a regular basis, kind of keep their real estate assets up to date in the trust?
Yeah, so it's helpful to purchase in the name of the trust if you have a trust already existing. But if you forget to put it in the name of the trust, or if the lender won't allow you for whatever reason, what I always tell my clients, I give them the trust schedules in Word format on a flash drive. And I just tell them to review it once a year, and they can just type it in. It doesn't even have to be full account numbers. It's, you know, as simple as we moved all of our Bank of America accounts over to Chase, or we're now at First Republic. If you just like write First Republic accounts or Bank of America accounts or Chase accounts, obviously you shouldn't be forgetting probably your address.
Yeah.
So if you're transacting in real estate, just putting the address of any new property that you have on this list, sending it to your attorney. You don't get billed or charged for that. They just update your file with your new assets. So the schedule of trust assets is one way to get assets into the trust. The pour over will is the second. And it just depends on the judge, but I've used a variety of different things to get something into the trust without having to go through probate. And sometimes it's as simple as a pour over will. Sometimes you need the pour over will and something called a general assignment, which is also part of the comprehensive plan, that says it's my intent to transfer all of my assets to the trust that can be transferred, whether now owned or acquired in the future. So that's also part of it. And then, of course, updating the trust schedules is the best option.
Yeah, awesome.
Can I ask?
Go ahead. Sorry, Heidi.
Just in general, because sometimes we get questions about, because we always recommend that our clients, when they purchase real estate, have a trust for all of these reasons. However, if somebody asks if they can do it during a transaction, a purchase of a property, we usually recommend that they kind of do it separately, just because it can seemingly be an emotional and like kind of lengthy maybe process. And I guess my question is, how long does it typically, for, you know, a simple like, you know, a married couple buying their first property, and maybe they have a couple assets here and there, but to set up a trust from the get-go, how long would that typically take, the runway for that? And then people just want to know how much it costs.
Yeah, so it usually takes between 1 month to 3 months, depending on the turnaround time, right? So the necessity in the signing that I'm doing today, I met with the client on Sunday, we're signing tonight. That's just because that had to happen tonight being Tuesday when we're recording this, which means that there was a 48-hour turnaround time, but that's because it had to happen that way. Most of the time it takes about 1 month to 3 months, depending on like the client getting information to you and those types of things. And the costs, I work on a flat fee basis, and most attorneys will offer a comprehensive estate planning package on a flat fee. For a single individual, it's usually $3,000 unless they don't need me to transfer the real estate. Then it can be $2,500. For a married couple, it's $3,500. And those are the base fees. Most people fit into the base fees. But if you're a real estate investor and have 10 LLPs and 10 pieces of real estate, it's going to cost a little bit more because we've got to transfer all of those business interests and all of those properties into the trust. But if you're just talking about one home and a couple retirement accounts, then you're fitting into the base fee.
Perfect. And we won't use the time frame it took myself and my wife to do their trust as a standard. So the kind of finish up on that whole, because we're kind of coming to the end of our time here. If we needed to ask more questions, or we wanted to find you or reach out to you, Jennifer, how do people find you?
So my website is just my name and has all my contact information. So it's just www.jenniferjaynes.com, and Jaynes is spelled Jay, and is a Nancy, ES.
Perfect. And everything's right there. And then is there anything before we go that we've not asked that is something that should, there you are, that people should know in regards to just a trust, or a quick, common, when you're in an elevator and somebody's like, oh, trust, I need to do one of those. What is there anything that that you say to that person?
Yeah, just don't wait. It's a relatively simple process. Like I said, you don't have to update it all that often. Most people don't. And it's a flat fee to do it. It's really relatively simple. And most people say, I don't have enough money to have a trust. But the truth of the matter is, the less money you have, the more you need that trust to avoid the probate fees. That people who are extremely wealthy don't bat an eye at the probate fees for a large estate, or maybe they do, but ultimately who it really affects is the people that don't have large estates and need to leave funds to their children.
Thank you so much. And then Hayley, in the dark, it looks like you're a little bit in the dark there. Where do people find us when they're looking for us?
You can find me in this dark corner a lot of the time, but you can find us at elevationrealestate.com, or on our YouTube channel. Just Google us, or on Instagram at elevationsf.
I love it. Thank you. Jennifer, you are a just source of great knowledge and help. Thank you for that. And we really appreciate all your help, and look forward to continuing to make sure everybody gets a trust. We all need trusts. Thank you.
Yeah, thank you guys for having me. It's always a pleasure. Thank you.
Thank you.